And I'm going to set bond at $10,000 rather than the no bond hold. Okay. Thank you.
Go to court on the 10th.
David Smith.
Conti, Your Honor.
Yes, sir.
Morning.
Good morning, sir.
All right, sir, you're charged with a violation of probation, count 2. This is on case 13-014-198-CF10A. There's a no bond call. This was Judge Shearer, and I find you over on that, finding probable cause based on the probation violation warrant. Okay, thank you.
Thank you.
What? You'll go to the judge on the 10th. Denard McGill.
Main jail, Your Honor.
Where are we?
Main jail.
Oh, okay. Okay. Now you can talk. All right, this is a possession of cocaine case. All right, do you want to tell me something? Counsel?
Your Honor, we asked the court to consider pretrial release for Mr. McGill. He has lived here for the last 32 years.
32?
He would be residing. Yes. He would be residing in Hollandale Beach, Florida. If he's released, he at the time was unemployed, but he lives with his family and would be able to show up to court if Your Honor releases him on pretrial release.
What says pretrial release? Okay. He gave you bad information, or you just nobody answered the phone, or what? They couldn't verify his references for pretrial release. They were getting all excited and everything. They were willing to just jump into this.
Is it possible we can verify the phone number for his mom? I believe he gave his mother's information.
Yeah.
Okay. 754 207
9065.
9065.
Is that what you already had? I will. That's what I'm going to do. I'm going to do a pretrial release pending verification.
Thank you, Your Honor.
If they're unable to verify, Your Honor, the bond remains $1,000.
That's right.
Your Honor, can we provide another number? Your Honor,
Yeah.
my apology. For Mr. McGill, can he also provide another number for pretrial to contact if his mother doesn't answer?
Say it now. They're here.
Okay. 754-368-8756.
Thank you, she said.
And for the record, there
Thank
was a
you.
finding of probable cause.
What?
And for the record, was there a finding of probable cause?
Yes, there was.
Thank you.
Daniel Lubin.
All right, I'll wait on my phone.
Okay.
I'm good.
Okay.
All right, counsel, on Daniel Lubin.
Yes, Your Honor.
All right. Good morning, Mr. Lubin. You have 5 counts. Count 1, fleeing or eluding a law enforcement officer who had the lights and sirens active, and that bond has been set at $2,500. Resisting an officer or obstructing without violence, and no bond was necessary at that point. Count 3, unlawful speed, and that no bond was necessary at that point. And count 4, driving under the influence of alcohol or drugs, second offense, $1,000 bond was set, and refusing to submit to a driving under the influence test, $100 bond. So I do find probable cause to bind you over. Okay?
Thank you, Your Honor.
Okay, thank you. Yevgen Primik. Counsel? Ask him
Mr.
how I...
Mr. Primich?
Counsel?
Oh, how do you pronounce your name?
Primich.
Primich.
Okay, I like to get it right. Okay, go ahead.
Mr. Primich indicated he has a private counsel.
Oh,
Okay.
does he know who that counsel is? We don't seem
Jane
to have that
Weintraub.
counsel here. What?
Jane Weintraub.
Well, all right, I'm still going ahead with this. In the meantime, since the counsel's not here, I'll go on the basis there is. It would be wonderful if there is counsel, but they may not have gotten a formal engagement yet. So, sir, you're charged with 4 counts. Each one is violation of probation. Count 1 is on case 12-014-790-CF10A, no bond hold. Count 2, violation of probation on case 12-014-118-CF10A, no bond hold. Count 3, violation of probation, case number 11-01-8922-CF10A, no bond hold. And count 4, violation of probation, case number 120137333-CF10A, also a no bond hold. These are all with Judge Destry, if I am correct.
Yes, Your
All
Honor.
right, I find probable cause to hold him over based on these, on the affidavits, and I'm going to find him over to Judge Destry.
Next day, June 10th at 8:30.
Okay, thank you. Shaquille Robinson. Good morning. All right, you have 4 counts. Count 1, touching or striking, which is called a battery. Count 2, exposing sexual organs in public. And that, now count 1 had a $1,000 bond. Count 2, 0 bond so far. Count 3 is a capias on a misdemeanor case 15-000-609. MM38, capias being an arrest warrant, $250 bond. And count 4, a violation of probation or community control, which is 15-00331-4-CF10A, no bond hold. violation with?
Yeah. Yeah, that,
That's on the KPS, on the misdemeanor with the judge?
yeah, the petty theft, Your Honor.
All right, I find probable cause, and there are a no bond hold on the violation of probation with Judge Hames, so that you'll be bound over for, that was the 11th? And you also have a KPS on the misdemeanor in front of Judge Wren on the 15th. Thank you.
Thank you.
Oh, 15th for Judge Wren, I'm sorry. 15th for Hames, okay. Lascelles Simmons. All right, you are charged with possession of cocaine. All right, I find probable cause. Anything you want to tell me?
Your Honor, we're asking if the court would consider
Yeah, we're-
releasing Mr. Simmons on his own recognizance or on pretrial release. He's 24 years old. He's lived here all his life. He lives with his mother here in Plantation, Florida, and at this time he is unable to afford the monetary bond.
Pretrial?
Hey, sir, you gotta sit up, man. You can't do that.
You
We
refused
almost
to
done,
interview.
man.
That's
We
not
almost
nice.
And Your Honor, for the record, he also has had traffic KPS before, so there is a history of not showing it.
Okay, I'm going to do a pretrial release pending verification. All right, sir, your address and your phone number.
8735.
Oh, okay. You know, if you want them to do anything, you better do it slowly and clearly. And you know, you don't want to be smart aleck about this.
Yeah.
Okay. 8735 Cleary Boulevard. That's Cleary Boulevard. That's Plantation, Florida. 33324. What's the phone number? 754 423 6629. And that's your mom. And that's his mother. Her name?
Okay.
Natasha
For the record,
Johnson.
Your Honor, are we finding probable cause?
I did it much earlier.
Okay, just check.
I did it, and then I said to the public defender, is there anything you wish to tell me?
Oh,
That was the sequence I went in.
That was the first thing you said, Your Honor.
No, the first thing I said was, good morning. The second thing was, I told him what he was being charged with. Then I got to that. And you were with me long enough, you know that I always say good morning or whatever to every single person.
You certainly do.
Okay. John Ferguson.
Good morning, sir.
Good morning. How are you, Mr. Ferguson?
Well, I'm not in a very happy state.
Well, lucky for you, you got a wonderful attorney standing next to you.
Great.
Okay. And, sir, you are charged with possession of cocaine and a violation of a city ordinance. Which was for an open container. I'm just telling you what you're being charged with at this point.
Yes, sir.
And I find probable cause to make sure the state attorney's okay.
Are you finding probable cause on this, Your Honor?
And, okay, I'm listening.
Your Honor.
Honor.
No, not to you anymore. Remember,
Your Honor, we are
remember, sir, I
asking-
told you you had a wonderful attorney standing next to
Okay.
you. Yeah, that's what you want to take advantage of at this point.
We are asking if the court would consider releasing Mr. Ferguson on his own recognizance. At this time, he is unable to afford the monetary bond. He does have a permanent address, Your Honor, here in Boca Raton, and so he would have somewhere to live, and he has agreed to show up to any court case that Your Honor would possibly set.
And you're not asking me for pretrial?
We would ask if Your Honor is not considering to release him ROR, Your Honor consider releasing him on pretrial release.
Pretrial, what say it?
Your Honor, we were unable to verify his information.
Here, need your information, address and phone number.
Repeat it slowly.
Address and phone number.
My address is 622 Fanshawe, Building O, Boca Raton, Florida 33434. My phone number is 561-376-5858.
What?
Okay.
We need a contact. Phone
He
number.
lives alone. He lives alone, Your Honor.
Okay, he lives
so there
alone,
is
but he has friends.
You have a friend's number, someone
Just,
who can
they
verify
just
that
need
you live
someone to
there?
contact so they can verify everything
That
you
you
just
live at
said
that
is
address?
correct.
Yes, sir. 561-715-4502.
And who might that be?
That would be my wife.
Okay. I think he said 561. I wasn't copying
Are we
anything
finding
down,
probable
though.
cause?
What is her name? Besides Mrs.
Miss Donna.
Ferguson.
Donna.
Donna Ferguson?
Yes.
Are we finding probable
Okay.
cause?
561-715-4502.
All right, here we go. Pretrial release. Pending verification. Am I saying all these things correct? Oh, okay.
Thank you, Your Honor.
I mean, I got the state attorney, watching there. I got to make sure I got it right.
Gotta get the probable cause. That's why we're here.
Brandon Anderson. Good morning. You want to be next to him?
My girlfriend and my business mom.
All right, sir, you have 9 counts. Counts 1 through 6 are all the same, and which is delivery of PVP, which someone like me has a very difficult time pronouncing. It is usually alpha pyrolydiopentophenone. Within 1,000 feet of a school, community center, or a park. And each of those 6 counts has a $5,000 bond. Count 7 is possession with the intent to sell or deliver the PVP within $1,000 of a school, community center, or park, also carrying a $5,000 bond. Count 8 is selling or delivering cannabis within 1,000 feet of a school, community center, or park, $5,000 bond. And then 9, possession of a weapon or ammo by a convicted Florida felon. So far, bond not set. So I do find probable cause.
Your Honor, as to counts 1 through 6, I'd argue that no probable cause should be found because although it indicates that Mr. Anderson sold PVP, it never indicates that this drug that was sold on these specific dates was tested and tested positive for any illegal substance. It's bare bones in stating on 2/20/2015, the CI purchased $50 worth of PVP from the listed defendant inside the listed residence. On 3/4, the CI purchased $50. It's the same thing for each day, but it never indicates that any of these drugs were tested by the officers and that they field tested positive or any lab reports were provided that they tested positive for any illegal substance. It's basically concluding that it was PVP.
For sure.
Well,
You said any of these drugs. There was a Valtox on the cannabis.
and there was
I saw
also
that.
there was also
Yeah.
field test
For the-
positive for. I'm sorry.
What?
I was just going to say, if you look at the second page of the probable cause affidavit,
Where I am right now.
yeah, it says that that all the drugs tested Valtox positive for the presence of cocaine, and based on the officer's knowledge, training, and experience, powder cocaine is an active ingredient added in PVP in order to heighten the effect of the drug.
You see that?
And Your
Counsel?
Honor, that's listed under on June 5th, 2015, additional 18 grams of PVP was found in the residence. So it's my argument that they're referring that they tested the 18 grams of PVP in the home, but they're not stating that these transactions that occurred on these other days were tested. That's referring to what occurred on June 5th. You be quiet,
Okay.
All right.
And today's June 6th.
Yes, Your Honor. So they're saying that they tested the drugs found in the home on June 5th. I'm not alleging that the possession of the drugs found on June 5th isn't an illegal substance. But as for the different transactions where he's charged with delivering PVP, there is no facts in the PC that support that this drug was actually PVP.
It says it should be noted that all the drugs tested Valtox positive for the presence of cocaine. All the drugs. Okay, I find probable cause.
And Your Honor,
Now, on count 9, which I haven't set bond yet,
there are priors, Your Honor.
well, I assumed there were. I want to hear them, but because it was possession
Right.
of a weapon by a convicted felon.
Yes, Your Honor.
So,
I didn't want to
tell
assume
me what
anything.
the conviction was.
Your Honor, in 2010, there was a possession of cocaine and cannabis. There was 12 months probation. 2008, possession of cocaine with intent to distribute and possession of cannabis, 1 year and 1 day in Broward County Prison, and time served on the possession of cannabis. In 2008, aggravated fleeing and eluding, resisting without violence, driving while license suspended with knowledge, served 1 year and a day, and time served on the misdemeanors. Let me see. In 2006, possession of cocaine, 1 year and 1 day, time served on possession of cannabis. And 2007, unlawful false name, identity, driving while license suspended, time served. 2007, possession of cannabis, adjudication. 2007, again, misdemeanor possession of cannabis. And then that's within 10 years.
count 9, I'm setting bond at $10,000, which has a total of then a bond of $50,000.
Your Honor, I'm asking if the court would consider cutting that bond amount in half, possibly. The mother of his 10-month-old child is in the courtroom. She is willing to bond him out, but unfortunately, she is unable to pay a $50,000 bond. So we're asking if the court would allow a lesser bond that's more attainable for the family members to possibly bond him out.
I'll listen to
And so we're
her.
asking if you're
I
considered
will listen to
$25,000.
her, but it doesn't mean I will do it, doesn't mean I won't do it. Okay.
Yes, Your Honor.
Go ahead, ma'am.
Yes, Your Honor, I am willing to bond him out.
Okay, how much can you bond? Can you pay?
10,000.
You have 10,000, or or you have 1,000 in collateral?
1,000 in collateral.
I can't reduce the bond to that. Okay. All right, well, thank you.
Your Honor, he indicated that he does have other family members that she can contact to
Yes, sir.
possibly get more money from in order to afford more of a bond. That's what we were asking for $25,000. He thinks that $2,500, 10% is attainable by family members if they were to pool their money together.
Yes, sir.
Well, the only thing I will do is on count 9, I will make that a $5,000 bond. So they're all consistently $5,000 bonds. All right, thank you. That's it, thank you.
Thank you.
Jason Kahn. All right, Con, you're charged with false owner information on pawned items, $300 or more, and dealing in stolen property. Each one of those 2 counts currently has a $3,500 bond set, and I do find probable cause. How are you, sir?
I'm okay.
Your Honor, we're asking if you would consider releasing Mr. Khan on pretrial release. At this time, he does not have...
Pretrial, what's the story? I'll do they couldn't verify, but I'll be willing to do it pending verification.
1 to 8 hours long.
Thank you, Your Honor.
What do you need from me?
It's on the phone.
First, give an
Address and phone
address
number?
and phone number slowly and loudly.
312 Northeast 1st Street, Deerfield Beach, 33441.
Can I get the phone number?
The phone number is 561-451. 6343.
Whose number is that?
Mine.
No, you have to give a number. Somebody can verify your address.
Oh, 929. 1934. 561 area code.
561-929-1934.
1934.
What's
Whose
that
number is
name?
it?
John Kelly.
Don Kelly.
And they're gonna say you live there. Okay.
Reuben Bronson, Jr.
North Broward.
Can I go to the bathroom?
Yes, sir. Hey, look, we're talking.
Can I go to the bathroom?
Down the middle line. Go on out there, so that's where you.
Good morning.
Good morning.
So you're charged with grand theft, between $300 and $5,000. Bond has currently been set at
$1,000.
at $1,000. And no, I haven't found probable cause yet. Is the PD here, anything to tell me?
Judge, I haven't had a chance to speak to him this morning. I don't think he can afford the bond. I can ask him.
That wasn't what I meant.
Oh, is it PC?
Okay, never mind then.
Well, Judge, there would be no probable cause because of the 65% certainty of the photograph lineup. No one else is an independent witness to it. There is I'm not sure if there is the quality of the video, but all the crime stoppers said that 65% certainty of identification.
Your Honor, if we look at the second page, third page, there was an admission.
All right, I find probable cause and pre-trial. Did you look at this one?
His sister's posting his bond, Your Honor.
I'm sorry?
His sister's posting his bond.
Oh, your bond's being posted by your sister.
All right, thank you.
All right. Marcian Menelis. Where?
He's in Maine, Your Honor.
Morning.
Good morning.
Good morning, sir.
All right. Sir, you're charged with violation of community control on case 05015-706 CF10A. And there's a no bond hold set by Judge Murphy. So I find probable cause based on the affidavit, and I will bind you over to Judge Murphy, and you will go before him on June 10th. That's in just a few days. Thank you. Fredwin St. Louis.
You're you should watch it, man. You're playing with fire.
All right, Mr. St. Louis, you're charged with violation of probation on case 043290CF10A, which is currently a no bond hold. Who's this with? I couldn't tell when I kept going through this.
Yeah. Ivan McCarthy.
Oh, okay. All right, I find probable cause based on the affidavit, and I get you over to Judge McCarthy on June 10th. Thank you. Gabriel Tovar. Good morning.
Good morning.
All right, sir, you're charged with violation of probation, which there's a no bond hold. This is on case 12-00-2763-CF10A in front of Judge Hames, I believe. And based on the, I find probable cause based on the affidavit for the violation of probation. And you'll be bound over to Judge Hames on June 10th. Thank you. Dennis Rodriguez. Did I say that correctly?
Did he say that correctly?
Good morning. Yeah, you said it. Boo Rodriguez.
Boo Rodriguez. Okay, good morning, sir. All right, so you're charged with 2 counts. Count 1 is grand theft of $5,000 or more, but less than $10,000, which a $1,000 bond has been set. Count 2 is passing a forged, altered bill or promissory note, and again, a $1,000 bond has been set. And I do find probable cause, and $2,000 has been set. Pretrial, what do you say? He refused. Okay.
Your Honor, we are.
There goes that argument.
We are asking if Your Honor would consider releasing him on his own recognizance. He is 18. It's his first adult.
Releasing him to pretrial.
Okay, we would also ask if you would consider pretrial. The issue with that is he lives with his mom. He does not know her number by memory, and her number is in his phone, and his phone is in property. So if Your Honor would write an order allowing him to access the phone to get the number, then he would be able to have someone verify the address. But he doesn't know the number by memory of his mother. But he does know the address.
Yeah.
So if they wanted to do a home
address
visit, they can
first,
also do
right
that. Address.
9420 West Flagler,
Apartment number.
413.
City.
Miami 33174.
He don't know nobody number.
No, nobody's.
What is your mother's name?
Mora
Last name?
Rodriguez.
Mora, I believe he said.
Yeah,
Last name Rodriguez.
correctly.
And, you have any objection to getting his mother's phone number?
To him giving you the phone number?
No. That he gets it, that I do an order saying he can get it from his phone. It's in his phone directory. He doesn't know by heart.
Oh, of course. Yeah.
Of course, you have an objection?
Of course, he can do that. If there was an objection, I would have said
Prepare
objection.
an order for that. I will.
Okay. So he's gonna let you. They're gonna get your phone, so you get the number out, and you get the free trial. Okay.
It's in my order. Okay. Pre-trial release pending.
How many charges did they get?
verification. All right, I'm going to sign that order too. So there you go. Did you get mother's
Thank you, sir. What do I have to?
number from his phone? Okay. Okay, I can't do anything more at this moment. I'm going to sign that order after local PD here fills it out for me. Okay.
All right, no problem.
Thank you.
All right.
Thank you,
David
sir.
Lindbergh.
North Broward.
Yes, Your Honor.
Good morning.
Good morning, Your Honor.
All right, sir. You have 2 counts of violation of probation or community control. These are on 2 cases. The first one being 11012869 CF10A, no bond hold. Count 2, violation of community control on 13006187 CF10A, again, no bond hold. Based on, I've read the affidavits and warrant, I do find probable cause based on that, and you will be bound over to Judge Porter. Thank you.
Wait, my judge is not Porter, it's Singer.
I thought you said,
He was in Tobin Singer for drug court, but I'm not sure if they transferred it over to Porter.
I've got,
So
I got Porter listed here.
yeah, it's
See what I
possible.
got on the affidavit. Good.
It's possible that that based off of these charges, he was kicked out of drug court.
I wasn't. How was I kicked out of drug court?
Stop.
I said it's possible, Your Honor.
Says Porter. I don't have Porter anymore. I'm just letting you know. That's why I got fired. Now I understand.
The warrant said Porter, or that was May of 2015. Both warrants were signed by Judge Porter
Mm-hmm.
on 2015
Yes, I see the same thing, Your Honor.
in May. So I think I'm correct. Okay. Public defender, thank you.
No problem.
All right, that's it.
Can I ask a question? Don't normally, if I violate,
No.
don't I see my judge within the week?
You're going to 16.
I don't know. Maybe your judge is
I have-
there. I don't know. Okay.
I have court the 16th with Singer.
Okay. Louis Cruson.
Main jail.
Gotta read her.
All right, you're charged with burglary of an occupied dwelling, but at least you weren't armed, they say. Good morning.
Good morning.
No, you don't talk. You don't talk. Just take them on. That's it.
That's why you got a good person standing next to you there. Well, actually, you're sitting down, so I shouldn't have said that.
You have small PCR,
I was wondering, okay. All right, well, all right, so you're charged with burglary of an occupied dwelling, like I said, unarmed. Okay, now, the public defender here wants to make an argument.
Yeah, Judge, as to the burglary charge, we would argue that there's no probable cause. It just says that Mr. Cruzen was in the enclosed curtilage of the victim's carport without permission. However, there's no indication they were there to commit a crime therein. They don't say what the crime they were about to commit or did commit. They just saw them in the enclosed carport and they leave. This is more of a trespass.
Your Honor,
One of the heads now?
one of the last page of the PC talks about the carport being filled with personal property.
Okay, but none was taken, so.
Correct, but they were in
Oh,
construction.
no, I didn't mean they didn't intend to, but,
Correct.
but I
So-
gotta have something that
Yes,
shows
Your Honor,
me
this-
they intended to.
Well, it's the state's position, at least at this point, that that they were in constructive possession of personal property not belonging to them within the curtilage, which can be attributable to knowledge or intent to commit a crime therein at that point.
Well, I don't have anything here that tells me they had that knowledge or.
Then in that case, Your Honor, the state would be asking for 48 hours to perfect a PC.
Well, I'm not finding probable cause, but I'll give you 24 hours to perfect.
Your Honor, just for the record, the state's asking for 48 hours
I know you
under
were.
3.133
But I gave
A1.
24 under the same.
Okay, thank you.
You know, why does the court would consider setting a bond in the interim?
I will set a bond in the interim of $2,500.
Thank you, Your Honor.
Okay, thank you. Marshall Ramsey.
Good afternoon, Your Honor.
Good morning.
It's still morning. I'm moving and
It is?
grooving here. We're going to try to get everything done
okay.
in the morning.
I apologize, then.
Nah, you don't have to apologize. I hope you're doing well. All right. But let that lady who's right there with you do the talking from here on, okay? All right. Sir, you're charged with the purchase of the drug PVP. I have a very difficult time saying the full name of it, but that's PVP, or also known as Flocker. That's, okay. And I do find probable cause. Now.
Yeah.
Out on pretrial for case number 140024810 for attempt burglary, conveyance unoccupied, and we're requesting that his pretrial is revoked.
On that one.
Yes.
Did you hear all that, PD?
No, Your Honor, I heard the beginning that he was out on pretrial.
Yeah, on
That's all
another
I heard.
case, and pretrial
Okay.
now wants me to revoke it, the pretrial release, because in their mind, at least, he wasn't behaving himself the way he should have under pretrial release. That's all I'm commenting. I'm not saying anything further than that.
Your Honor, if Your Honor is inclined to revoke pretrial release on the other case, we're asking if you would set a monetary bond on that case.
Yeah, the other case is an attempted burglary of a conveyance or an unoccupied dwelling, I assume. Unoccupied building, I should say. Okay. All right, I am going to revoke the bond on that. Anybody know any more details on that one?
Yes, Your Honor. It's on the attempted burglary. It was a $1,000 surety bond. It's in front of. It's in mental health court felony right now in front of Judge Porth. In VZ, FC.
Is it mental health?
Yeah, right now it's in mental health felony in front of Porth. The attempted burglary under case number 142481 CF10A.
All right, I revoked it, and I will set a bond there of $1,000. Yeah. Thanks. And on the PVP, I'll reduce the bond to $500. Yep.
What was the bond on the attempted burglary?
1,000 is
Thank
what
you.
I set. I don't know what this is.
Thank you, Your Honor.
I didn't saw it. My fault. Okay. Having too much fun. All right, Jesse Cooper.
He bonded.
Oh, okay, bonded.
All the questions you want for the day, sir. That's it. Oh, done. Hey,
John Ballerschmidt.
tell them this one. Yeah, you trying to get out of here.
Good morning.
Good morning, Your Honor.
It's gonna be at the end.
You say you said it can $2,000 bond, right?
All right. Sir, you're charged with 2 counts. Count 1 is fraudulently attempting to use an identification of another person without that person's consent. A $1,000 bond has been set. Count 2, the unauthorized possession of a blank, forged, or stolen driver's license, of which also a $1,000 bond was set, and I do find probable cause. Do you interview him, Pretrial?
Your Honor, he refused also.
He refused to be interviewed, public defender.
Your Honor, he indicates that his family and friends can bond him out with the current bond that's set.
They're bonding him? I didn't hear what you said, I'm sorry.
His family and friends will bond him out if Your Honor leaves the bond as it is.
Okay, fine.
Thank you.
Benjamin Callens.
North Broward.
North Broward.
Good morning, Mr. Callens.
Good morning, Your Honor.
Mr. Callens, they say that you were charged with burglary of an occupied dwelling, though not armed, and a no bond hold on a grand theft pending case 15005047 CF10A.
Yeah.
Okay, on, I find probable cause on count 1 of the burglary of an occupied dwelling unarmed, and I will set the bond at $2,500.
Your Honor, he does have priors.
But that's okay,
Okay.
because on count 2, the grand theft
The no bond.
15005047 CF10A, I'm maintaining the no bond.
Okay.
That was court ordered by Judge
By
Lee.
Judge Lee.
That's not who he's bound before, but that's
Correct.
okay. Based on the probable cause found by Judge Lee in his warrant, which I read, then we will hand him over. Thank you.
Yes,
Joseph Winston.
North Broward.
Good morning.
Good morning, Your Honor. Good morning.
Good morning, sir. You're charged with 3 counts. All these are drug-related possession counts. Count 1, possession of alprazolam, which is also known as Xanax, $1,000 bond. Count 2, possession of lorazepam, which is also known as Ativan, $1,000 bond. And count 3, possession of diazepam, which is Valium, and $1,000 bond. I do find probable cause on those. Pretrial, did you do anything? Winston. Good morning, sir.
Good morning.
Okay, sir, I'm going to have you interviewed by pretrial release about possibly being released on your own recognizance. How's that sound?
Very good, Your Honor. Thank you.
Right. Would you give your regular address slowly and loudly?
4135 Northwest 113 Terrace, Sunrise 33323,
Phone number.
Telephone 954-448-1078.
Now, who's that phone number for?
The cell phone, that's my phone number.
All right, do you
Your Honor.
give us the phone number of someone else who could say where you live?
Oh, I'm sorry. My mother, 954-448-0933.
And can you give me her name, please?
Diana Winston.
Diana Winston, okay? All right, now, if you are released pre-trial, you will also have to do random drug testing and possible, a drug evaluation and follow through. Do you understand that?
Yes, Your Honor.
Okay, good. All right, thank you. William
Thank you, sir.
Sands.
North Broward.
Yes, sir, Your Honor.
Hi, Mr. Sands.
Good morning, Your Honor.
Mr. Sands, you're charged with burglary of an occupied dwelling, but not armed, trespass of school grounds, and loitering or prowling. Bonds have not been set on any of those. All right, I find probable cause. Did you do any checking on this, pre-trial?
At your discretion, Your Honor, the burglary occupied dwelling, at your discretion.
Does he have a history?
Well, Your Honor, in 1989, there was an attempted murder in the first degree that was disposed in front of Judge McCarthy.
Disposed of in what way?
He can consider that.
Like a dully
Sure he can.
prosecutor, not guilty.
He was sentenced to 3 years, looks like. He pled guilty to attempted murder in the first degree.
Well, that didn't go over well then. Okay, well, we're not doing the pretrial release. All right, I am going to set a bond on count 1 of $3,000. Count 2, $100, and no bond will be necessary on count 3. Okay, thank you.
Okay, Your Honor.
Kenton Beck.
North Broward.
Yeah, got him. Good morning, Mr. Beck.
Morning, Your Honor.
Okay.
All right, sir. You are charged with lewd, lascivious act upon a victim 12 years of age up to 16 years of age on a pending case of 15-005-212-CF10A, which is a pending case. A capias or warrant for your arrest was issued with a no bond hold by Judge McCarthy. I have read it. Therefore, there's probable cause, and based on that warrant signed by Judge McCarthy, and I bind you over. Thank you. Raymond's June 10th. All right. LaCharles Coakley.
North Broward.
Good morning. How are you?
Good morning, sir. All right, sir, you're charged with burglary of an unoccupied dwelling, unarmed, with a capias, that being an arrest warrant, on case 15-006051, CF10A, which there is a no bond warrant from Judge Siegel. So based on his no bond hold, I find probable cause and bind you over. His arraignment is.
I've been in custody ever since I got arrested on this charge.
Okay.
That's nice.
The correct date was, I believe, the 8th. The 8th
Signed on
of
June
May.
2nd, 2015 by Judge Siegel.
Yes, Your Honor.
Well, issued by Judge Siegel.
Yeah, RR, right, correct.
June 10th is what we have. Well, would you try to tell me? I'm sorry. Stand up. I'm having a hard time hearing you. I don't mean to.
It's a change of charge, maybe, if I believe it's in the officer's discretion to set a bond. And I can say correctly if I'm wrong, because it's not that you didn't.
Charge haven't been filed. They haven't been filed.
June 2nd is when Judge Siegel issued this. This is the 6th.
I was arrested on the 8th for the same charge.
Your Honor, I'm looking at.
Yeah, this is Coakley.
Yeah, I'm looking at the same thing you are, Your Honor. And Judge Siegel issued a capias for no bond hold. June 10th.
But I think it's, all I'm saying is I think it's in your discretion if you want to set a bond in the burglary case, because it was a change of charge. I don't know what it was a change of charge from.
Do you see a change of charge, anybody?
It says on the bond.
You work for it.
Your Honor, I would object.
I'm leaving it as it is because it's Judge Siegel's.
I was arrested on the
bond
charge
on the change of
on the
charge.
8th.
Thank you. Marvin Gray.
Who was the person me coming on?
Come on out.
I don't understand what you have.
Yeah, what do you have? I don't have anything.
All right, so you're charged as follows. You have 2 counts. Count 1 is possession with intent to sell or manufacture or deliver PVP, which is that long one that I can't pronounce very well. You currently have a $1,000 bond, and then trespass for property that was not a structure or a conveyance, and no bond has been set on that. I do find probable cause, and on the okay. Pretrial? What do you say? I can't hear you. He's home? Oh. You don't have a place to live, sir?
No, sir.
PD, you saying anything to me? Does he have a record?
Yes, Your Honor.
For?
2011, in front of Judge Robinson, there was a obstruction of an officer by disguise. 2009, loitering and prowling and resisting obstruction without violence. He had a possession of a controlled substance with intent in 2007, and the rest, I believe, are juvenile.
Trying to figure out something here I can do to help. Having a very difficult time coming up with anything. If he's homeless, I don't have a way of contacting him to keep this running.
Mr. Gray, do you have anywhere to live?
No, I was staying at my job.
Where's your job? Well, I don't want to go into it. You go into it, counsel. I can't.
Well,
Where do you work, Mr. Gray?
I work at the Sunoco gas station over there by Copins and Bitson and Pompano.
And you said you were living there?
Yeah, my the owner of the property, she lets me stay inside.
Do you have the owner's information, their name and phone number?
And address.
And address.
No, I can't remember the phone number by heart.
Do you know the address and the name?
I know, I think it's on 20. I think it's on 22nd Street.
See, the thing is, we need an exact address, Mr. Gray, because pretrial can't verify an address, and then you won't be able to be out on pretrial. So, so they the court and pretrial are going to require a verifiable address and phone number.
Well, you can.
No bond necessary. 0 bond on count 2, count 1, $100 bond. Okay.
100?
What?
100?
I find probable cause. I think I already said that, but just to make sure, so that the state attorney doesn't have a problem.
At least not with this. Yeah. Dixon.
Dixon? I didn't say it was yours. Tyrone Dixon.
Oh, I'm done?
You're done.
What?
Council in the back gave me an address for that Sunoco gas station on Instagram. Something you want to give free trial, maybe they can verify it that way. We just Googled the Sunoco on.
Fine, very nice of you.
I had a minute.
I just wondered if that's where you got your gas.
It's 2350.
Give me back that prior case.
Right.
The gas station case.
Let's all pick up my memory.
The last one we did.
Nope, hopefully we are, okay.
Okay.
The address one?
What?
I'm sorry, we waiting for that?
I'm listening to you.
It's, the address that I got was the 2351 North Power Line Road. And it's in Broward Beach.
On Copin, that's the one that came up on Copins, and I just thought I'd help. I don't know, maybe I didn't help, but felt bad for the guy.
And it's 954 969 5728.
if not, it's still the $100 and no bond necessary on the count two. Okay, thank you. Thanks. Well, I got one more case. On Dixon. Tyrone Dixon. Where's Tyrone Dixon?
Main jail?
Oh, okay. Nobody told me. I didn't mean to leave you all alone.
Morning.
Good morning, sir.
Good morning, Judge.
Yes. I'll go ahead and run it. Okay.
Okay. Sir, you're charged with burglary of a dwelling or structure, conveyance while armed, and possession of a controlled substance. Oh, sorry. I have a very difficult time reading the up here. Possession of controlled substance without what's press stand for? What? Oh, without a prescription. Okay, because I thought it was something else. Okay. Yes, PD.
Your Honor, we don't get, Your Honor, not find probable cause on this case, as there's no victim listed at all.
Well, I'm having a lot of problems with it, actually. I don't understand this about the hospital. All of a sudden, I got a hospital in this. You see that, State?
Yes.
Can you explain that?
No, but I can let you know that being in a hospital is not a element of a burglary. But it does jump out at me as well, Your Honor.
But if he's in the hospital, it says while in the hospital, it was hard to commit a burglary at another place.
Well, it does say he was in that other place first. I'm assuming at some point between that place and here in the jail, he was in the hospital. I'm sorry?
It's a big assumption. Okay.
Yeah. And Your Honor, we also expect you not find it. Oh, go ahead.
You were ahead.
Okay.
All right, no probable cause, 48 hours.
Thank you, Your Honor.
Your Honor, we asked if you would set a bond in the interim.
The state would be objecting to that, Your Honor.
Well, what weapon did he use?
That was the other argument. There's no weapon listed.
You said he was armed.
Yes, Your Honor.
What weapon?
Within 48 hours, I can hopefully let you know, Your Honor.
Hopefully. See, okay, I'm going to set a bond in the meantime. gonna set a bond of $5,000 on count 1, and I'll leave the 1,000 on count 2. Okay. And,
Thank you, Your Honor.
and I gave him time to perfect.
Thank you.
Okay. Now this is the add-on. Nicole Barnett.
Judge, good morning. Good to see you. Happy Saturday.
Always
Brad,
thrilled
I'm
to
Brad.
be here, but it's nice to see you. It's been a long time.
I know. You're out in the woods for us over here, but it's good to see you. I'm here on Nicole Barnett, Brad Collins on her behalf. Her husband, who is the complainant on the case, is also present, who's actually here to...
I haven't read anything.
Oh, okay, sorry.
No, but go ahead. I'm listening.
Well, everything I'm going to say is right in there. Actually, it's one of the more complete representations from what my client just told me. And yeah. There's Nicole.
I was like, you just said yeah.
Yeah, because she was scheduled to be on a docket tomorrow. That's a photocopy. I can forward the original PC to the clerk tomorrow.
I'm sorry. I was trying to read. All of a sudden, I don't mean it offensively, but I didn't hear you.
She was scheduled to be on magistrate tomorrow, so the original PC is still at the jail. I can forward the clerk the original PC. That's a copy of the PC that you have.
Is there any difference?
No.
Other than the color of the ink or something?
I'm sorry?
Other than the color of the ink or?
Yeah, that's the only difference.
I actually had a blue ink one here today. Yeah, it was pretty. Okay, has any bond been set at this point?
No, because it's domestic violence, the charge, that's why.
Okay, I know. I just want to make sure, because I find out things are being scheduled and all that.
That's right.
I want everything clear, that's all.
She had gotten arrested before midnight. We would hope, thank you for adding her on. We thought she'd be on today.
I'm happy to hear it.
But her husband is Henry Barnett. He's a police officer with Coral Gables Police Department. They live in Weston. His wife, you read in the PC, his ex-wife and he have 3 children.
Triplets.
Triplets, correct. And his ex was at the house. She and the ex had a bit, she wasn't happy that the ex was there, but it's going to be an ongoing thing. Mr. Barnett did not get hurt, has contacted me right away. He's going to be contacting the state about seeking not to prosecute the case. He's asking that there not be any no contact order and that you ROR her or set some very low bond, but he's not threatened by her, he was not injured by her, but he called the police to defuse the situation, knowing that the police would come there and probably not realizing, even being a police officer, that she wouldn't be able to get out, that but he did defuse the situation, and so if you want to hear from him, he's right here, but that's what he's offering.
There's one problem I have overall. He being a police officer, he's probably armed. And, I mean, everything makes a lot of sense, but nonetheless, when he's armed and there's a gun in the house, no, I'll get to you. There's a weapon in the house, I don't know what he has.
That's correct, but you can, I think you have the discretion to set whatever conditions that you want on it. It was not, this was not, if you read that, I wanted you to see the PC, because if you read it, it actually, it reads, I think, on the lower level of these domestic types of cases. I don't think that he was threatened in a way that he was going to be hurt, but he just wanted to diffuse it quickly and didn't want to make it any hotter than it needed to be, but he was not in danger of being harmed by her. I don't think she threatened to use any kind of a weapon on him, so I think that the thing that you're concerned about is not an actual, something that you have to really worry about. And there, everything is locked up, and he has the code. There's no excessive, I mean, there's no allegation that she was threatening in that way. I think she was just upset that the ex-wife is going to keep coming around. The ex-wife's not very healthy and doesn't have contact on a regular basis with the children, and he's trying to allow access with the children, and that's what really this was about. And that will probably be something they have to resolve going forward in their lives no matter what. But I think it's something that shouldn't have really had to come to us being in court on this. And I hope, yeah, we did. And I'm going to try to get him to the right people in the state attorney's office, that hopefully it won't go further after that, but it's going to take a little bit of channeling to do. But in the meantime, you can see the distress on her face. She's got no prior. She's never been violent with him before. If you want to hear that directly from him, I can tell you, okay.
Your Honor.
Say your name.
Sorry, I'm Henry Barnett, and that's my wife, and we live together. We've never had a history of violence.
How long have you been married?
8 months together, 3 years and change. We've never had a history of violence. The issue with my ex has come up before, and we've kind of reached an impasse and agreed to go seek counseling on it, but this week it just boiled over, and last night it boiled over, and
This is what I'm concerned about, is the boiling over, and you have, I presume you have firearms in the house.
They're locked in
I wouldn't want a boiling over once again,
I understand, sir. They're, at least for...
I'm sure you've seen things like that as a police officer.
Yes, sir. They are locked up. Only I have the code, so it's not that anybody else, not the kids, not her, can get to them. Then it's a habit of mine to walk in the door, and before I say hello to anybody, I go put everything away.
You weren't concerned about this escalating to that kind of a level at all?
No, never had that kind of concern, but we've never had violence in the house in any shape before, and this took me by surprise.
I would just suggest, Judge, it's not often that the female is on this end of things in here, and so I think the officer, knowing the system and being able to call the police and defuse it, I would be willing to bet that if he was able to diffuse it a different way now, knowing how it was going to go, that he probably would have done that. And
okay. All right. When I find probable cause, I'm going to set the bond at $2,000 total. Now, I am not going to, and I need you to prepare an order.
Okay.
I am not going to do a no contact. However, I am going to order, this is what you need to, that any firearms have to be secured without access by the defendant, and that counseling by the defendant, accompanied by you is fine, I don't care, and you bet begin this week, this coming week. I just can't have this boil over, okay?
Yes, sir.
No, I don't hear domestic violence cases much because I'm in a regional courthouse. It's just something that we really watch out for. Nothing to do with you, just something that we really are watching.
How should I draft the defendant shall not have contact with the weapon? I don't want her to be in violation of her own order if she's in the house with him, so...
Well, I'm just ordering that the weapons not be secured in the household without her having any access. So that's actually applies to him.
Okay, I'm just not sure how we can put it in her order of release. I'll put it in there, but,
I signed her order already for a $2,000 bond.
okay.
And
You're just instructing
I did
her.
not sign the no visitation. This is a separate order.
Okay, I don't need to write, I need another one, then I'm sorry. So I don't need to put the bond as status, just add that the defendant shall not have possess firearms and the husband will not keep them secured.
Right.
Okay. And she's a,
Of course, she's not to use any drugs other than prescription,
okay,
you know, the usual on that stuff.
okay, thank you very much.
They must, I don't care.
Counseling.
Counseling beginning immediately. Within the next 5 days. Okay. Thank you.
Thank you very much.
Thank you, Your Honor.
Okay, anything else?
Not from us, Judge. Thank you very much. Thanks for calling it.
One matter, Your Honor.
If I can
He's got one matter. I don't know if it's changed or not.
Okay.
I did receive information from one of the Viper units email that there was an arrest made on Dwayne McLean, case number 15-4899-CF10A, and we'd be requesting on that case that you sua sponte revoke bond on that case.
Do I know who this person is? Did I have something with them? The name isn't striking a bell.
That's the email we got from Eric.
Where's your code? Oh, there.
Is that someone on the docket?
Not on the document.
Okay. Well, we'd ask that a written motion and a hearing be set to revoke bond.
Okay. I'm bringing to the court's attention. I was instructed to do that.
Okay. I just had, it was just one case that was called earlier on page 7, Kelly Davila.
I don't have
and
a
I
docket.
just wanted
I
to.
don't care. They don't give me a docket. I just get individual sheets. Okay, go ahead.
I'll walk you.
Thanks. Do you know what happened on Kelly Davila on page 7? Medical reset?
Okay. Now,
Okay.
counsel, stay where you are.
Yes. Okay. I'm not going anywhere.
Thank you. It was a pleasure having you here today. Okay?
Thank you, Your Honor. It was a pleasure working with you as well.
Thanks. Okay. Enjoy the rest of your weekend unless you're on tomorrow.
You too. No, I'm not here tomorrow.
Okay, enjoy that.
John Moore.
Okay, nothing further?
I have this for you real quickly, Judge.
MORHAIN.
I don't have the case number.
Court's adjourned.
MORHAIN.
We can modify this later.
Thank you.
That's all I have. Okay, I'll just put that.
I'm going to a nice little girl's baby name.
501 502 688.
Wait, for that too. Thank you.
Well, actually, it was good seeing you again.
Wasn't it?
It was.
Wasn't it? As if there was a question.
And a pleasure with you.
Nice to meet you.
See, you missed never being in my division. He can attest to. We actually had a good time during it all. We take it seriously, but we have a good time while we're doing it.
Oh yeah, he gives me a hard time.
I'll walk you. It'll take a little while for that bond.
Good, I just said I give him a hard time.
What?
Like when I asked 4 times in the same case, he called us, because I knew it bothered him. Yeah, I'm over on Judge Orlando's right there.
Oh, okay, good, yes.
Hey, nice to see you.
Nice to meet you too. Hey, have a good weekend.
We need to take it.
Here, did you read it?
I did.
Okay, I just want to make sure.
Oh, that one? No, I thought it was the other one. Let me do a look.
Yeah, before I sign anything. So make sure.
I thought it was just for the other case. No, that was
I haven't got a problem, Brad. I just want to make sure he sees it.
Yeah, no problem. I just didn't want her to be in violation. If somebody misreads that and thinks she's in the house and there's a weapon and they just don't get what you're coming in, does that read okay?
Yeah, I'm fine. Okay.
Sounds good.
Okay, good.
All right.
Don't turn anything off.
What was that?
That's that.
I don't touch anything.
No, everything's off.
They emailed me back.
Let's see, we need to go, it's gonna take a while for the papers to get over there, probably.
The email
If you want, you can just call that bondsman. It'll cost you $200 on a $2,000
I have no idea.
bond.
Oh, the one that-
You just gotta post it.
SAO
Thank you.
magistrate
On the other
ASA.
posting, Bill, how long does it take you to
Magistrate
get to them?
ASA.
If he goes over there now.
At SAO.state, SAO 17, that, you know, all that stuff.
So magistrate ASA.
Yeah.
Okay. So you got that one, right?
Yes. Wait, which one? Hold on, just give me a sec. This.
He'll monitor it all
Yes.
day for you and just get it done.
It's your call.
Well, and you
No, I get it.